Hi, my name is Akiva Goldman. I'm an attorney with Goldman and Associates, and today I'd like to talk about the finality of orders. You know, in a divorce case, there are certain things that once the court makes its determination, that's it. I mean, you can go to the Court of Appeals if you don't like it, but you're pretty much going to be stuck with it. So, for example, if the court awards a bicycle to one party in a divorce as part of the property judgment, the court orders it, there's very little you can do about it. Like I said, you can appeal, but that's basically it. Filing a motion and asking the judge to give it back may or may not work, probably not. The court has heard all that. There are some things, though, that are always subject to review by the court. Most things about children are always subject to re-review. And why is that? Well, the court looks at the needs of a child to be an evolving process. The court looks at things involving children to be something that it always has to be very vigilant as it makes rulings about it. And maybe what made sense today doesn't make sense anymore. So for example, suppose we had a choice of school ruling where we decided that child should go over to this school because even though maybe it's not so good, it's closer to mom, and mom has the custody. Well, now the kids are learning online, so maybe it doesn't make sense anymore. Maybe that's not part of the analysis anymore. Maybe we put the kid in the better school now because the kid's online. In other words, there are things that can change about what goes on every day that might impact the child. So the court is always willing to look at things about children again. That could mean custody, support. It could also mean parenting time. So a lot of times I'll get the question, well, the court ruled that I can't get more parenting time. What do I do? And the answer is that while it's bad that the court ruled against you, the good news is this can always be revisited. I wouldn't go filing another motion the next week and asking the same thing that the court just denied. But what I would do is I would honor the court's ruling, try to let it go for a few months without incident. Don't get into it with your spouse. Develop a closer relationship with your child as best as you can. Be as good of a visiting parent as you can be. And then maybe in 90 days, 120 days, maybe 6 months, ask the court for more time. When things are going good, the court is always looking for someone who wants to, and receptive to someone who wants to be more involved with their child's life. And if the court sees that you have a good faith desire to be part of your kid's life, and at the same time that the other side is just trying to freeze you out, the court is likely to grant your request because the court is going to encourage both parents to be significant in the life of the child. So if the court denies your parenting time, go with the existing order, let a certain amount of time pass, do it expertly and perfectly without any incident, and then come back before the court and ask for more time. In a situation like that, it's a policy of the state of Michigan to encourage more time with the parents, so that's a request that the court should be able to easily grant. If you have any questions about that, reach out, and of course we'll be glad to help you out. If you found this helpful, please like, comment, and share.